Welcome to In Conversation with Kashmir Times. I'm Anuradha Bhasin, and joining me today is Mr. Manish Tewari, Congress parliamentarian. Now, last week in the Parliament, the Union Home Minister criticized Nehru for two blunders, announcing a ceasefire in 1948 and letting Pakistan take control of territories that are called Pakistan-occupied Kashmir, also for taking Kashmir to the UN. And you have opposed these claims. You said that Nehru was acting on the advice of the army general. Could you elaborate on that? You did mention an article in The Guardian and the classified papers.
Well, first of all, Anuradha ji, thank you very much for having me in this conversation. It's always enlightening and stimulating to speak to you. Nehru seems to be the favorite bugbear of certain people. So even many decades after his death, a lot of things, a lot of blame is put on his doorstep. But before I set out to answer your question, let's understand the context of those times. The world had just emerged from a devastating Second World War in which millions of people had been killed. For the first time, mass extermination, or what we call the Holocaust, had been perpetrated on the Jews during the Second World War. It was for the first time that the devastating potential of the atom had been unleashed on two helpless Japanese cities, Hiroshima and Nagasaki. And it was in these times that the United Nations had been created. And India was a signatory or a founder signatory to the United Nations Charter, even before it became independent. And these were the events that led up to India's partition and independence in the August of 1947. Subsequently, I don't want to recount the entire history of what happened from the 23rd October 1947 onwards. But suffice to say that there was an invasion perpetrated by Pakistan, and the fighting went on for the better part of a year and a quarter. Towards the end of 1948, when General Roy Bachar, who was the commander-in-chief of the Indian Army, and both India and Pakistan had British military commanders at that point in time, gave considered military advice to the Prime Minister and his cabinet, Prime Minister Nehru and his cabinet, that more military gains were not tenable, and therefore a political solution needed to be explored. And that is what led up to the ceasefire. After considering the military advice which was given, which is that no tangible progress on the ground is possible, that a ceasefire came into effect. And insofar as the United Nations is concerned, as I was explaining earlier, given the context of the horrors which the world had seen, the United Nations was created after the failure of the League of Nations in order to ensure that conflicts are not settled by violent means and there's a peaceful settlement of conflicts. Now, yes, there is a quibble as to why the Nehru government chose to approach the United Nations under the Charter of Settlement or under the Article of Settlement of Disputes and not aggression. Well, with 6x6 hindsight, you can try and second guess every decision. But I guess in the circumstances that India found itself dealing with the aftermath of a horrific partition, an unprecedented transfer of people, more than 20 million people were displaced between the July and the August of 1947 alone, the integration of 562 princely states into India. So therefore, Jammu and Kashmir, or the problem in Jammu and Kashmir, was not the only thing that the government of India at that point in time was dealing with.
Yeah, and you know, like you said, it's the BJP's favorite to tarnish the image of Nehru, and this is not the first time that they have talked about Nehru going, taking a wrong decision with ceasefire or going to the UN. And they've been trying to build this narrative that while Nehru was for the ceasefire and he went to the UN, Patel was not. Whereas several scholars have pointed out, and there are also exchange of letters between Patel and Nehru to show that they were on the same page. Would you agree with that?
Not only Patel and Nehru, even Shama Prasad Mukherjee, who was a member of the government, was on the same page. In fact, Shama Prasad Mukherjee had spoken somewhere that the decision to go to the United Nations obviously had his approval, as he was a member of the cabinet then. So therefore, it is not that Nehru was unilaterally trying to override his other cabinet colleagues who were as tall leaders as him. And so whether it was 370, whether it was the ceasefire, whether it was taking the Jammu and Kashmir question to the United Nations, the entire cabinet at that point in time, and there were huge stalwarts in that in that government, they were all essentially on the same page. I have not read any dissent anywhere of any of Mr. Nehru's erstwhile cabinet colleagues.
No, the Shama Prasad Mukherjee also gave his assent to 370 at that time. So would it then be correct to say that the autonomy to the region was inevitable in light of the developments preceding it?
Well, the Maharaja of Jammu and Kashmir negotiated a certain a certain agreement with the government of India, and that agreement had an intrinsic autonomy inbuilt into it. And so, therefore, those were the terms which were settled between the then government of India and the then government of Jammu and Kashmir, led by Maharaja Hari Singh. So these are all matters of historical record.
Yeah. In light of the fact that the Supreme Court verdict on 370 would soon be out, so it would be pointless debating about the legality of the revocation of the, J&K Reorganization Act. But I would just like to bring in one point that you made last week in the Lok Sabha while debating the amendment bills. And you said that the strategy to abrogate Article 370 was laid in December 2018 when the presidential notification imposing president's rule in Jammu and Kashmir, it suspended the second proviso to Article 3 of the Constitution of India. So what exactly is this proviso?
So essentially, again, let me rewind back a little. You see, on the 5th of August 2019, which was a Monday, when Parliament met, nobody had even an inkling that what is going to happen over the next 2 days. Suddenly, the Home Minister appeared in the Rajya Sabha at 11 o'clock. And without any pre-consultation, which should precede any legislation, and in fact, there's a pre-consultative legislative policy of 2014, which is in place, but which has not been followed over the past 10 years. Without circulating the bills to to members of Parliament. In fact, every bill should be circulated according to the rules at least 72 hours to 48 hours in advance. It cannot just be bounced off a completely ignorant or a completely clueless Parliament. But that's precisely what happened. And so therefore, it was laid on the table of the House. It was steamrolled through the Rajya Sabha. And so, even when it came to the Lok Sabha the next day, it wasn't very clear as to how this was being done. Yes, there was a J&K reorganization bill. There were these constitutional orders, but to kind of put all this together and prepare for a debate, and I'm saying this because since I led the debate in the Lok Sabha on behalf of the opposition, was simply a very impossible task. Subsequently, when the hearings commenced in the Supreme Court, and since we had also intervened, I, on behalf of a colleague from the Northeast, I started looking at all the documents very carefully. And there I found that in March 2015, when the PDP-BJP alliance government was formed, there was an agenda of governance which was conceptualized. The agenda of governance very, very clearly said that the constitutional arrangements between the state of Jammu and Kashmir and the Union of India will not be touched, irrespective of the fact that we have different perceptions on these. Then between 2015 and 2018, the government functioned in the manner in which it functioned. And subsequently, the BJP withdrew support in the June of 2018 and governor's rule was imposed. After 6 months of governor's rule elapsed, when president's rule was imposed, there is a standard clause in all presidential proclamations that as much of Article 3 as it constitutes a reference by the union to the states shall be suspended. This is standard language in every presidential proclamation going back to the 1950s. But there was a very interesting formulation in the Jammu and Kashmir presidential proviso. And that formulation was that not only the first proviso, but the second proviso, and explicitly mentioning the second proviso, stands suspended. Now, the second proviso says that before you introduce any bill in Parliament to reorganize a state, you must ascertain the views of the legislature of that state. It is a mandatory pre-qualification for introducing a bill to reorganize any state in Parliament. And so that created a suspicion that what happened on the 5th and 6th of August 2019, the foundations of that were being laid as far back as the December of 2018.
So it was premeditated.
Obviously, it was premeditated because if you can get all the presidential proclamations, they're there on the Government of India's Gazette notification website. I took 7 of them to Parliament the next day because the Home Minister had challenged me on this, saying that this is a standard clause. And then I read out the distinction between the standard clause and what had been done in the case of Jammu and Kashmir. And obviously, there was no answer. So my sense is that the planning for dismantling the constitutional or the special constitutional architecture of Jammu and Kashmir had commenced, as early as December 2018, or if not earlier.
The J&K Reorganization Amendment Bill 2023 now provides nomination to 2 Kashmiri migrants and 1 POK refugee. So while you oppose the bill on technical grounds that the matter of reorganization is sub judice in the court, and in light of that, an amendment to it would be fundamentally flawed. Correct me if I'm wrong. But you have not opposed the contents of the bill.
Absolutely.
Does the bill itself not subvert the very purpose and nature of the representational democracy?
Well, so therefore, let me first add something to what I was saying earlier. So when it came to the reorganization of Jammu and Kashmir, in addition to suspending the second proviso, and of course it is, as you said, academic to debate it now, since on Monday the judgment would be out. But it's very interesting, when they reinterpreted in Constitutional Order 272, inserting Article 367(4) into the Constitution, that the Parliament of India would mean the legislature of the state of Jammu and Kashmir, is essentially converting Parliament into the legislature of Jammu and Kashmir. They forgot that in the Jammu and Kashmir Constitution, there is an Article 147, which says that no bill can be introduced in the legislature of Jammu and Kashmir, which alters the constitutional arrangements
Right.
between the state and the Union of India. So it is fundamentally flawed in many grounds. But insofar as your question is concerned, then why didn't we oppose the substance of the bill? Well, there is nomination provided for in Parliament. In the Rajya Sabha, 10 people are nominated. So in the Lok Sabha earlier, 2 people from the Anglo-Indian community used to be nominated till the time this government in 2019 did away with that reservation. So a minuscule number of people being nominated to a legislative body is not something which is happening for the first time. If I remember correctly, in some states also there is this provision for nomination.
Firstly, I like to take it, point by point. Firstly, the government it's the governor who's going to nominate. And the governor usually, earlier, the J&K constitution laid down provisions of the process for nominating members. 2 women members were being nominated to the J&K assembly, but this was done on the advice and recommendation of the elected government. Now, here, under the present rules, the governor will be arbitrarily handpicking random people. Is that not problematic?
So therefore, now that's a question of interpretation. Once popular government is restored, obviously, and if statehood is restored, there will be no lieutenant governor. You will have to read governor, lieutenant governor to mean governor. And then, yeah, I mean, once, if you restore statehood, you will not have a state being headed by a lieutenant governor, right? It would be a governor. So first of all, you'll have to read a lieutenant governor to mean governor. And then, obviously, once you have a popular government, the governor only acts on the aid and advice of the Council of Ministers. He will not be able to do it arbitrarily. Yes, till the time there is no Jammu and Kashmir Legislative Assembly, or let us say when it gets constituted for the first time, nominations always succeed in election. You cannot announce an election and say that I nominate these 2 people to an assembly which doesn't exist. The assembly will come into existence only when an election takes place. The election commission certifies the results and a proclamation is issued bringing the assembly into existence. Now, once an assembly is brought into existence and there is a popular government, the lieutenant governor will obviously have to act on the aid and advice of the Council of Ministers till the time it's a union territory. And once, full statehood, if at all it is restored, then the governor will have to act on the aid and advice of the Council of Ministers.
The earlier nominated members, the 2 women who were nominated in the previous arrangement, they did not enjoy voting rights. But Section 15 of the J&K Reorganization Act, under that, the union government has retained the provision of nominating the 2 seats, but giving them voting rights. The new 3 more members have been added, nominated members, and this increases the tally to 5. So this is a huge number. We have when the size of the assembly of the elected representatives is just about 90. And in case the nominated members are nominated by the governor before the floor test, it will completely change the floor arithmetic. It will tilt the balance in favor of the BJP.
So I will answer this in 2 parts. What you're saying is problematic. Like, for example, in Rajya Sabha, the nominated members have voting rights, except during the election of the President of India.
Yeah.
Because they are nominated by the president, so they can't vote in the person or vote in an election of the person or the institution which has nominated them. We had a similar problem in Chandigarh with the municipal corporation. The municipal corporation has 10 10 nominated members who have voting rights. And therefore, then people went to court and said that, you have 20 elected members and 10 nominated members who have voting rights. This is completely undemocratic. And if I remember correctly, the Punjab and Haryana High Court has stayed their voting rights. The matter is still under judicial scrutiny. So yes, you are right. This voting right is going to be problematic, and at some point in time, it will have to be judicially adjudicated.
Also, on another count, is the reservation really fair for the people, even for the people who are getting it, say for the migrants who were promised peace, return, and rehabilitation? And all that the government is now doing is offering them SOPs with 2 assembly seats, but no territorial constituency. Secondly, would this kind of a reservation also open up Pandora's box? Other communities may start seeking more reservation. The POK refugees are already saying, we are more in number. And if they are getting 2 seats, why are we getting 1? So is it opening a Pandora's box as well?
See, Anuradha ji, I am not an expert on the politics of Jammu and Kashmir. I, of course, come from your neighboring state, so therefore have a academic.
That kind of applies, to any part of India. The kind of diversity that we have in India.
So I have an academic interest in this, but if I may say this, the tragedy of the Kashmiri Pandits has been a humongous tragedy, and unfortunately, across governments from 1989 onwards, we have not been able to do justice to them. And so, therefore, under those circumstances, conditions must be created whereby they can return to the state, they can return to their homeland, they can participate in an electoral representative process on their own strength. And we've had stalwarts from the Kashmiri Pandit community, both in the government of India over the years, and of course in the government of Jammu and Kashmir. And one can only hope that one day, this situation will be restored and people will be able to live in peace and harmony. And till the time that doesn't happen, obviously some kind of representation which gives them a voice, I don't think is unjust. And that's why we did not oppose the bill on substance.
And what about elections in Jammu and Kashmir? There have been no elections since 2014. And why are elections not being held? People are now asking, when will elections be held, if at all? It's now come to the question of if.
Well, I asked the Home Minister those 2 questions, that A, when will elections be held, and B, when will statehood be restored? So except for answering those questions, he said everything else. So, and yes, it is very interesting. During the Supreme Court hearing, the Supreme Court had asked the principal law officer of the government exactly the same question. And I had read out the reply of that law officer in Parliament, where he said that I am not in a position to give a timeline. Right? So therefore, there are contradictions, because if you go back in time and space, the Home Minister has been saying that statehood would be restored. His Minister of State said that statehood would be restored when normalcy returns. Now, on one hand, the government is claiming that everything is hunky-dory, that 2.5 crore tourists were going there, homestays are happening, Jammu and Kashmir has become a land of milk and honey. And so therefore...
They're taking the tourists right up to the line of control. Yeah. So what's the logic?
So obviously, if everything is normal, then test it out through an electoral process. then, election should be held, statehood should be restored if everything is normal. That is what the entire opposition demanded. But there were no answers to those two questions.
In 2020, the government rushed through the delimitation, even though there was a nationwide freeze on delimitation till 2026, and only with respect to Jammu and Kashmir. And the exercise has been seen by many critics as one of the worst examples of gerrymandering of boundaries to suit the BJP. So why are they still holding back, even after that delimitation commission?
Well, to the best of my knowledge, I think delimitation was challenged in the Supreme Court, and that challenge could not be sustained. I think possibly maybe the grounds on which it was challenged was not something which found favor with the Supreme Court. But whether we like it or not, the delimitation has now attained a finality. Whenever elections will be held, they will be held on the basis of the territorial constituencies that stand delimited. So under those circumstances, I can only agree with you that when you think, or at least there's a perception that even the delimitation suits the powers that be, it is very strange and it is very confounding as to why they are holding back on the elections. Because you see, fortunately, Jammu and Kashmir, after the ceasefire agreement with Pakistan, the international border and the line of control have been peaceful. So, therefore, under those circumstances, if let us suppose there is external peace, and then government claims that everything is hunky dory within the state, then obviously there could not be a more opportune moment for having elections.
So either they're not very confident about.
Well, ultimately, in an election, somebody wins, somebody loses. You had the Hill Development Council elections in Kargil, right? So therefore, an electoral process played out. 78% of the people voted. The result went in a particular manner. It did. I mean, it happens in elections.
So the tenure of the urban local bodies and the panchayats is now over. And the elections are long overdue, but they have not been announced. And the government recently reasoned that in light of the fact that the applicability, because of the applicability of the central laws in J&K, it is now mandatory to hold elections after delimitation of the municipal constituencies. Should that be a legal hitch for holding elections to local bodies, urban local bodies?
I think, in my estimation, I have not looked at it from a purely legal standpoint, and the answer which I would give you would be an ignorant answer, and I would not want to do that. But all that I can say is that the starting point now should be first restoration of statehood, and number two, elections to the Vidhan Sabha. And then once you have an elected government in place, let it take the call as to how they would want urban local bodies and panchayats, etc., to be elected. Because eventually, this is the responsibility or the remit of a state government. And once you put a state government in place, they will then start discharging these functions, because it is not very healthy, to have a situation whereby the buffer of state representation between Delhi and Srinagar continues to be non-existent, because when it has happened in the past for an extended period of time, the consequences have not been very good.
In the past, elections were seen as a measure of democracy in India, and though that really is not the only measure of democracy, but even that has gone. So would you say that Indian democracy has failed the people of Jammu and Kashmir?
Well, Jammu and Kashmir has been unfortunately undergoing rather long spells of president's rule / governor's rule, now going back all the way to 1952, when on the 8th and 9th of August, Sheikh Abdullah was arrested by the then government of India. And even if you come to the 90s, from 1990 to 1996, Jammu and Kashmir was under president's rule. Then from 1996, you've had an uninterrupted run till 2014, when elections were being held after every 6 years. And I think it is incumbent upon the government of India, whosoever is in the government, to ensure that the fundamental legitimate democratic aspirations of the Jammu and Kashmir people, now that the entire process of delimitation, everything is complete, should be allowed to play out and take its natural course.
We can only hope that your sane advice falls on there.
I hope so.
Yes.
Well, a lot will turn on the way the verdict plays itself out on Monday. And so therefore one can only hope and pray that justice is not only done, but justice is also seen to be done.
Yes. Let's hope so. Thank you so much.
Thank you. Thank you. Thank you.